Hi everyone, welcome to Lawyer Up by NDV Law. I am Attorney Karlo Nicolas, a senior partner of Nicolas in the Vega law offices. Today we are going to discuss about data privacy in the Philippines. Information and communications technologies, these all play a vital role in nation building and the development of the country. In the information age, he who holds information holds power. And from a macroeconomic perspective, the free flow of information is consideredly vital to the growth of any nation and key to the success of any business. With the power that follows information, it is in the interest of the state to govern the parameters by which such power will be held, while at the same time ensuring the free flow of information to promote innovation and growth. From the perspective of citizens and individuals, the state also protects their fundamental human rights to privacy of communication. And with the exponentially increasing availability of ways and means to access personal data and information, it becomes the duty of the state to guard against transgressions of the individual's rights. Republic Act No. 10173, otherwise known as the Data Privacy Act of 2012, is one formidable piece of legislation. Its application encompasses all walks of business, from the banking industry to the finance sector, to labor and human resources, schools, and even non-profit organizations. This is, of course, not to say that the Data Privacy Act of 2012 finds no application to individuals and citizens. On the contrary, the units of information supplied by these people in the Philippines comprise the whole, which the Data Privacy Act of 2012 protects. Thus, access to private and personal information belonging to individuals is covered by its mantle of protection in the same manner as trade secrets held by global conglomerates and multinationals. The Data Privacy Act of 2012 protects all forms of information that are personal, private, or privileged. It covers all persons, whether natural or juridical, with particular emphasis to companies, juridical entities involved in the processing of protected information. It is important to note, however, that by its very title, the law only protects information that is considered private. Information that has been publicly available or accessible before its enactment continues to be public. The value that the Data Privacy Act of 2012 adds to the present state of Philippine law is the manner by which private or confidential information is protected. To be more specific, the passage of this law to a great extent upgraded the value of data and its protection in the Philippines. And to this end, the law specifies and provides stringent parameters for their access and imposes grave sanctions, both penal and pecuniary, for unlawful use or disclosure of information. As a matter of fact, the Data Privacy Act of 2012 upgraded the liability for a violation of its provisions. Never before has there been pecuniary liability expressly specified in a law as high as up to 5 million pesos. Moreover, unlikely in the past where negligence in handling confidential information is not met with penal sanction, the Data Privacy Act punishes negligence in handling information with great severity. Finally, only until its enactment that a large-scale violation of data privacy was defined. It may be important to state that the law imposes the maximum penal sanction where the personal information of at least 100 persons is affected or involved. To give an idea of how strict the current state of data privacy laws in the Philippines are, here are some of its penal provisions. Unauthorized processing of personal information or personal sensitive information is a crime, where persons process personal information or personal sensitive information without the consent of the data subject or without being authorized under the law. This is penalized by imprisonment ranging from 1 year up to 3 years and a fine of up to 2 million pesos for the unauthorized processing of personal information, and imprisonment ranging from 3 years up to 6 years and a fine of up to 4 million pesos on persons who process personal sensitive information without the consent of the data subject or without being authorized under any Philippine law. The penalties are the same also for persons who knowingly or unlawfully violate data confidentiality and security data systems by breaking a way into these systems where personal sensitive information is stored. Accessing personal information due to negligence is also penalized by imprisonment of up to 3 years and a fine of up to 2 million pesos. This is imposed on persons who, due to negligence, provide access to personal information without being authorized under the law. The penalty of imprisonment of up to 6 years and a fine of up to 4 million pesos is imposed if the information accessed involves personal sensitive information. Persons who knowingly or negligently dispose, discard, or abandon personal information of an individual in an area accessible to the public or has otherwise placed the information of an individual in its container for trash collection is punished with imprisonment ranging from 6 months to 2 years and a fine of not less than 100,000 pesos but not more than 500,000 pesos. Now, if the information negligently discarded involves sensitive personal information, the penalty is increased to imprisonment of up to 3 years and a fine of up to 1 million pesos. The next crime is the processing of personal information for unauthorized purposes, which is penalized by imprisonment of up to 7 years and a fine of up to 2 million pesos depending on the nature of information illegally processed. Now, there are other crimes such as concealment of security breaches involving sensitive personal information, malicious disclosure, where a personal information controller or personal information processor or any of its officials, employees, or agents, with malice or in bad faith, discloses unwarranted or false information relative to any personal information or personal sensitive information obtained by him or her. Unauthorized disclosure of information, all of which are met with the penalty of imprisonment and fine, again depending on whether the information that was violated is personal information or personal sensitive information. Now, if a combination or series of crimes is committed by the person, the penalty of imprisonment is increased to up to 6 years imprisonment and the fine also, which is now up to 5 million pesos. Take note that if the offender is a corporation or partnership or any juridical entity, the penalty will be imposed on the responsible officers who participated in the acts or who by their gross negligence allowed the commission of the crime. On the other hand, if the offender is a juridical person, the court may suspend or revoke any of its rights. If the offender is a foreigner, he or she shall, in addition to the penalties prescribed in the law, be deported without further proceedings after serving the penalties prescribed. Finally, this is what we call large-scale offense. A large-scale offense is where personal information of at least 100 persons is harmed, affected, or involved. If it's a large-scale offense, the maximum penalty will be imposed on the offender or offenders. We have now discussed the importance of the Philippine Data Privacy Act and its penalties. If this video was helpful to you, kindly hit that subscribe button. You can also visit our Facebook page and our website ndvlaw.com for a wealth of legal resources. Again, this is Attorney Karlo Nicolas of Nicolas and the Vega Law Offices. And thank you for watching Lawyer Up by NDV Law.